Hello everyone and welcome back to our channel. My name is Malescu and I am the owner of Malescu Law, a law firm based in Miami, Florida, specializing in business, corporate and US immigration. We can assist you with all your immigration needs regardless of where you are currently located or where you plan to go in the United States. Today we are going to speak about an important timeline and transition rules in light of the new law that eliminates the duration of status for F-1 international students in the United States. Now, it is important to know that the international student offices within the universities will have the most up-to-date information on how these transition rules regarding the F-1 international students apply in practice. But also, do not be surprised, because we have heard from international students, if the universities, if the international student offices also cannot answer all the questions, and especially when it comes right now to how easy it is to obtain a CPT during the academic year. But before we get started, please subscribe to our channel by clicking the bell button or the subscribe button. Now let's speak about the timeline and transition rules as we understand them today, following the new rule that eliminates the duration of status framework for F-1 international students. So first of all, the new rule that eliminates the duration of status framework for F-1 international students becomes effective on September 15, 2026. If you are currently a student in the United States on an F-1 student visa admitted under the old duration of status framework, then you may remain in the United States without having to file an extension of stay on Form I-539 with the United States Citizenship and Immigration Services, and you can remain in the United States up until the program end date that is listed on your Form I-20 or the end of your validity of the OPT or STEM OPT, but the maximum up until November 14, 2030, which is 4 years from the date the rule becomes effective, plus another 30 days grace period that you receive. Another important rule: if you are currently in F-1 student status for 60 days, when the new rule will become effective on September 15, 2026, and you will timely file an application for OPT or STEM OPT by March 18, 2027, then you do not need to file an extension of stay with the United States Citizenship and Immigration Services on Form I-539. However, if you travel internationally, so if you leave the United States before you file your application for OPT or STEM OPT, then upon return to the United States, you will be admitted under the new rule guideline for a fixed period of time, and then you will need to file both the application for OPT or STEM OPT and the extension of stay with the United States Citizenship and Immigration Services. And for those of you who are in the process of transitioning from the F-1 student visa to the H-1B status, you can get the cap gap protection if you are the beneficiary of a timely filed cap subject H-1B petition. Then you get the gap protection, and you do not need to file the extension of stay with the United States Citizenship and Immigration Services. This is all for today. Thank you so much for watching. If you need to ask more questions, please feel free to contact our office. Our contact information is in this video and below this video. We will see you soon. Bye.